I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. I was attacked by some people, and I was protecting
Sir,
my life.
I know you don't
Okay.
want my representation, but I would advise
No, ma'am, no, ma'am, no, ma'am, no,
I would
ma'am. Please
advise
don't.
that you not
Please
talk about
don't.
anything that happened.
Please don't. I have reiterated that Latavius Church Authority is a nonprofit organization. I am not a surety. I am shoulders.
Do you have a medical marijuana card?
Mr. Thornton does not know.
Was the GPS ordered if he was released?
That's not necessary.
No.
I have
Okay.
children.
Just a minute. All right.
We're looking at a tense hearing where a defendant, charged with assaulting 3 police officers, tries to derail the proceeding with pseudo-legal arguments. He tells the judge his name is a nonprofit or LLC, denies jurisdiction, and insists he's innocent, all while talking over the court and stretching the hearing with non-stop commentary. The judge stays composed, but the message is clear. Courts run on statutes, evidence, and procedure, not on theories that have no legal footing. These tactics don't dismiss charges. They often prompt warnings about decorum and can invite consequences like contempt if order breaks down. What stands out is how quickly self-representation can backfire when it's guided by internet scripts instead of applicable law. A stronger approach would have been to let counsel speak, respond directly to the judge's questions, and focus on the facts of the case. When a defendant treats the hearing like a debate over imaginary rules, the court simply returns to the record, the charges, the evidence, and the next steps. That's exactly what happens here. As we dive into the clip, watch for 3 beats: the judge's calm boundary setting, the defendant's repeated jurisdiction claims, and the moment the court moves past the noise to set conditions and timelines. Let me know your read. Do you think these arguments ever help? Or do they only make a hard day in court even harder?
Melissa Vachon with the Office of the Public Defender. Your Honor, I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
Okay. And Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavius Church Authority, which is a nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like it's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn. Okay. But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable. Okay.
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir.
Mr. A?
Mr. Thornton. So if you want to appeal,
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavius Church Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton. So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. Well, no, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail.
Can I please?
Because here's the thing. I don't want to be disrespectful to you.
Right, absolutely.
I know it feels disrespectful, but here's why. Here's my concern.
Some sovereign citizen defendants walk into court acting like the rules don't apply to them. They'll interrupt whenever they feel like it, as if the courtroom is running on their personal timeline, almost like they are starring in a show instead of facing an actual legal proceeding. It's wild to see how casually they disregard the structure that everyone else is expected to follow. From a practical standpoint, judges are there to keep order and move through a full docket of cases. When someone continuously speaks out of turn, it doesn't just look disrespectful, it slows down the entire process and wastes time for everyone waiting on the hearing. There's a proper moment to present arguments or make statements, but some people insist on doing it at the exact wrong time. And Zoom hearings have only made this behavior more noticeable. Being behind a screen seems to give certain defendants this false sense of freedom, as if they can just talk over the judge like they're in a casual group video chat. The courtroom might be virtual, but the consequences are still very real, something a lot of people seem to forget.
I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm fine with you doing most of it. But please, to protect my free speech, could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just simply let me know? And
okay.
I am aware that I am innocent until proven guilty, and that something I say could, like you said, come back and haunt me. I'm well aware of that for the Tavis Church Sean Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent, unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. And now I'm going to read the charges against you because you have a right to know them. Okay? You can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for. No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you
But
get to
that's-
reading, can I make one statement, please,
Well,
Your Honor?
you can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor, and that is why I feel it necessary for me to make certain things known for Latavius Treshaw Thornton, for that the script so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Latavius Treshaw Thornton to the courts. I have those full intentions. And so that you guys can be safe from all liability of Latavius Treshaw Thornton as his representation. That is the only reason why I speak in the way of please refrain from calling me Mr. Thornton and certain things, because it's pertinent for you guys to know I've already been treated as the surety. I am not the surety. I'm really shoulders. Like, if you guys meet my people, you will find out I'm really shoulders. Latavius Treshaw Thornton is really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. So with that information, I understand that the script goes a little different, and I understand that. I have the right to let it be known that I'm not the surety, and nobody has. I'm sorry. And
Okay. All right.
Yes,
So
ma'am.
here's
Your Honor.
here's the
sorry.
thing. That's okay. That's not an issue.
So, this individual is confidently insisting that his name is Shoulders, asking the court to accept it purely on his personal declaration, even claiming others would confirm it. But in a legal setting, it simply doesn't work that way. A courtroom doesn't operate on nicknames, aliases, or self-appointed titles. The court recognizes official identity, not whatever someone decides to call themselves that morning. Legal proceedings are not informal gatherings or personality showcases. No matter what someone chooses to identify as, the judge must address them by their verified legal name. This isn't a stage for dramatic monologues. It's a formal process with real consequences and strict structure that applies to everyone equally. What makes the moment even more unexpected is how long the judge allows this speech to continue. It almost feels like the courtroom has paused to observe a personal performance rather than staying on track with scheduled procedures. You can even sense the confusion from others present, as if they are unsure whether to intervene or let it play out at this point. It becomes surprising that the judge hasn't used courtroom tools to regain control, especially in a virtual hearing where muting is just one click away. The situation is on the edge of turning from unusual to completely off the rails, and it raises the question, is patience being shown, or is order slowly slipping? What do you think? Is the judge being respectfully patient or letting it go too far?
So in count one, you are accused of police officer assaulting, resisting, and obstructing. And the specific allegation is that on or about March 9th, 2025, at Carey Street and Lake Lansing Road in the city of Lansing, zip code 48912, you did assault, batter, wound, resist, obstruct, oppose, or endanger Kayla Bevere, a police officer with the East Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is a felony, punishable by up to 2 years in prison and or $2,000 in fines. In count two, you are accused of assaulting, resisting, or obstructing a police officer, again, on or about March 9th, 2025, at Carey Street and Lake Lansing in the city of Lansing, zip code 48912. Specific allegation is that you did assault, batter, wound, resist, obstruct, oppose, or endanger Chris Shattuck, a police officer with the East Lansing Police Department, that the defendant knew or had reason to know was performing his or her duties, contrary to Michigan law MCL 750.81D1. This is, again, a felony, punishable by up to 2 years in prison and or $2,000 in fines. Lastly, in count three, you are accused of, again, assaulting, resisting, or obstructing a police officer. And the specific allegation is that on or about March 9, 2025, at Cary Street and Lake Lansing Road in the city of Lansing, zip code 48912. You did assault, batter, wound, resist, obstruct, oppose, or endanger Colin Lemire, a police officer with the East Lansing Police Department, that you knew or had reason to know was performing his or her duties contrary to MCL 750.81D1. This is, again, a felony, punishable by up to 2 years in prison and or $2,000 in fines. Now, how do you wish to plead?
I don't. You said a lot, so can I address them part for part first?
No, not right now. So here's what I'm gonna do. I'm gonna enter a not guilty plea on your behalf, and here's why.
Can I ask you this first before you enter that plea? If me giving you a plea right now, will that be in response to everything that you just said?
Nope. So a plea would have you pleading. Would have you pleading guilty to all those charges. We've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes, 3 felonies, without having seen the evidence against you. So you can stand mute and the court enters a not guilty plea, or you can say you want to plead not guilty and you'll be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider it, among other things.
It's a bit more to it, Your Honor. That's the issue. So I will, based off of the things that you stated, that's not what my understanding is. From my understanding is I was attacked by some people and I was protecting
Sir,
my life.
I know you don't want my representation, but I would advise.
No, ma'am.
I would advise that you not talk about anything that happened.
Please don't, ma'am. I appreciate that.
Absolutely unbelievable. This defendant is walking into court with the confidence of a seasoned attorney while making some of the worst decisions imaginable. You can practically imagine the prosecution sitting back calmly, ready to let him talk himself straight into trouble, because that's exactly what's happening. That it could not be more obvious that he needs legal representation immediately. This isn't a vlog. It's not a public statement. It's a legal proceeding with long-term consequences. Yet sovereign citizen defendants keep doing this at arraignments. Instead of listening to the charges or seeking counsel, they launch into emotional speeches about their innocence before anything has even officially begun. The justice system does not reward volume, interruptions, or improvised legal theories. Speaking impulsively at the start of a case is one of the most dangerous moves someone can make, especially without understanding the legal framework they're stepping into. 5 minutes of proper legal guidance could prevent hours of self-inflicted damage, but they refuse it every time to this point. It's hard to tell whether it's denial, overconfidence, or an absolute disconnect from reality. The behavior feels less strategic and more self-destructive with every sentence. I genuinely can't figure out if this is extreme ego, misguided belief, or something deeper going on mentally. What do you think? Is this pure delusion, total denial, or just unchecked pride taking over?
I'm aware of why you're doing that, but I'm aware, like I said, me and the judge, I told her something that I might say could come back to haunt me. I'm already aware of that. So thank you so much, Miss Melissa, but please do not intervene. But once again, back to you, Your Honor. From my understanding, I was assaulted, and I am shoulders. Once again, I have never told anyone. Wait, I don't want you to mute me, Judge. This is going back to the situation. Okay, thank you. I never told anyone that I am Latavius Trayshawn Thornton. Not one time. I have reiterated. I am shoulders. Latavius Trayshawn, not just to you, Your Honor. That's so to be redundant for the record. Okay. I have reiterated that Latavius Trayshawn Thornton is a nonprofit organization. I am not a surety. I am shoulders. I am appointed to be an administrator for Latavius Trayshawn Thornton. No, that's why I'm here, but not a surety for Latavius Trayshawn Thornton. Furthermore, Your Honor, my understanding is I was attacked and assaulted, and I'm not sure if I could let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from this, all the evidence that they have gathered. I would like to use it in my assault case against East Lansing Police Department and its agencies.
Now, next up, we have some dates when you're going to return to court. And let me just pull those up here. Okay, okay, go ahead.
Yes, I just wanted to speak on my previous court history and let you know why it may look the way it looks.
Okay, no, here's the thing. I'm going to ask you to not say anything because I don't want to accidentally become biased.
Gotcha.
So, all right, so here are the dates. All right, you're going to come back for a probable cause conference at 8:30 a.m. March 21st. Now you're going to get this in writing, okay? 8:30, March 21st. We're going to move on to bond or bail. So would you like to be released on bond or bail?
Could you explain the difference to me, please?
Your Honor, I was going to ask for a bond. People
Okay.
have.
We're going to let Mr. Anid go first. All right, Mr. Anid.
The people are looking at MCL 765.6. Some of the factors to
Now
consider.
you're cutting out. I'm sorry, go ahead.
If he says something like that, would it make you biased? Couldn't you be speaking to make you biased?
Well,
right now?
I'm going to come back to you in just a minute, okay?
Okay, no problem.
All right, Mr. Nid, I'm sorry you were cutting out, but please.
Your Honor, the people are looking at some of the factors to consider bond. The people are asking for at least a $25,000 cash surety and GPS tether if he does post bond. We're looking at the seriousness of the offense charge, the protection of the public, the previous criminal record, and the dangers of the person accused, the probability or improbability of the person accused appearing at trial of the cause. All those factors are not in favor of the defendant, Your Honor. He failed to appear for sentencing in, I believe, circuit court. And again, Your Honor, if the court has updated the lien, if you can see if he has a warrant from a couple years back, that's from pleading for attempted resisting and obstructing, is what my note indicates. Protection of the public, Your Honor. This case involves assault on officers. I think one officer got punched in the face. The previous criminal record, he has 4 criminal histories from 4 different states, Your Honor, pending from.
Okay, no, he's going to get, and then I'll hear from you, okay?
And his probability. Your Honor, lastly, he failed to appear for several years on sentencing. He's not going to appear for this case if he gets released. I just asked for a high bond and a GPS tether if he posts that bond. There's a lot of risk to the public in this case, and he obviously he has ties to Indiana, Kentucky, Georgia, and one other state, Your Honor. This is a problem.
Okay.
Thank you.
Okay, now.
Before we get to bond,
Okay, I'm going to give you a chance, but here's the thing. Because there are certain key words, because there are specific things attorneys ask for, do you want Attorney Vachon to address this on your behalf? Because she's really good at this. I will tell you, she's really good at this.
can I say some things to Attorney Vachon before I make that determination? Right here.
Yes, Your Honor. Could we take a brief recess and I could have a breakout room?
Okay, so you're going to be in a breakout room with just Attorney Vachon. Then we're going to come back. Nobody's going anywhere until after you've had a chance to come back, okay? One moment, please.
Okay.
We'll put you in a breakout room. Thank you.
Thank you.
Okay, so I'm going to start with, Mr. Nid has spoken. I'm going to start with Attorney Vachon. Attorney Vachon, anything from the breakout room?
No, Your Honor. The defendant will speak for himself.
Whoa.
Okay. Sir, please proceed.
Okay, Your Honor. Thank you. Mr. Thornton is not a flight risk.
The first thing he declares is that he's not a flight risk, and that alone is alarming. When a defendant volunteers something like that before the court even raises the question, it instantly raises suspicion. It suggests they're already trying to steer attention away from a deeper concern. And in this situation, the context makes it even more serious. This is someone accused of assaulting 3 police officers, reportedly making direct physical contact and striking one in the face. That's not a minor allegation. Any judge is obligated to evaluate not just flight risk, but the potential danger to public safety. And with charges like that on record, the concern is entirely justified. The problem is, opening with a defensive claim like that completely unprompted doesn't calm the situation. If anything, it signals a lack of awareness about the gravity of the case. It makes the court even more cautious, and believe it or not, what he says next goes even further off the rails. At this point, you genuinely start to wonder whether he understands what's at stake or if he's treating the process like something it's not meant to be.
He has multiple properties in the Michigan and the Lansing area that keeps him here. Also, he has a lot of things he do here. He's a coach for 4th grade, 5th grade, 6th grade basketball teams, and they play year round. He's also a mentor to young children and to people who have had traumatic situations. They call on a daily. He's a counselor to the community and to the public. Furthermore, he's not a danger to the community or based off of his innocence, and he's not a threat to anyone in the society. He is actually beneficial to Mr. Thornton is actually a beneficial role in the community, and kids and multiple different areas of people, they look up to Mr. Thornton, and they will attest to his character as an upstanding, nonviolent, peaceful individual who brings smiles and love to the community. And he, once again, may I reiterate, is not a flight risk. Yes, he has ties to other places, but those ties are not as pertinent as to the ties of where he originally was born and reside and has grown as a part of this community and in a very effective way.
Okay, thank you. That's very well said. Sounds like Mr. Thornton really has a lot of good qualities. Okay, so I am looking at the file, and I want you to bear with me a bit. There was a song when I was younger. When I was in high school, there was a popular song that said, "Cruel to be kind." Okay, I'm looking at this, Mr. Thornton, and there's a warrant out of 30th Circuit Court, downtown, East Lansing. Okay.
Yes.
And this is from 2022, and it's a statewide pickup, no bond with extradition. So here's what I'm gonna do. I'm gonna come back to that in just a minute. I'm gonna set a money bond of $10,000 because all of the days that you don't post that bond, you will get credit for the time. If I gave you a cash bond, what would happen is Ingham County would pick you up on this old warrant and hold you until that case was resolved. By setting a cash bond on this, you get credit for the days you're in. Then, when that's resolved or close to being resolved, I will reconsider the bond amount. We call that making a bond motion, and I'll entertain that. But right now, this is cruel to be kind, okay? I know it's not what you want, but having been around the law long enough, this means they're going to keep you in custody for some time. So I want to be sure that you get something for it. Now, I'm going to put some other conditions on the bond for when you're able to bond out. And you're going to get these in writing, but I need to read them to you, and they need to be part of this record. So if you want to appeal, it's all here for you so they can evaluate whether I did this right or not. So number one, if you post bond, you may not leave the state of Michigan without prior permission from this court. Number two, you are presumed innocent, but the court says we have to tell you this right now. You may not commit any crime while released. Doesn't mean I think you're going to, but you have a right to know that. Number three, you must immediately notify this court in writing of any change of address or telephone number. Then, you must not use alcohol, recreational marijuana, or any illegal controlled substance. If you have any medications, you must take all medications as prescribed. Do you have a medical marijuana card, sir?
I'm sorry?
Do you have a medical marijuana card?
Mr. Thornton does not know.
Taking a step back from this entire situation, it's hard not to be stunned by how absurd his strategy is. He's seriously trying to convince a courtroom that he isn't a person, he's an LLC. As if redefining himself as a corporation is some secret legal cheat code that erases real criminal charges. It's not brilliance, it's chaos disguised as confidence. The court deals in documented reality, not imaginative loopholes. You can't avoid responsibility by declaring yourself a business entity. Yet he's delivering this argument like it's the master plan that's going to outsmart the entire justice system. It almost feels like satire until you remember it's happening in an actual courtroom. And it's wild how far this mindset has gone. We were promised a future of self-driving cities and advanced AI. But somehow we ended up with people trying to trademark their own names and register their existence like a vehicle title. It's ridiculous, but in a way, it's darkly comedic. So yes, when the judge set a $10,000 bond, it felt like the only reasonable decision. Because if someone walked out of court after making claims like that with no consequences, I think a lot of people would start questioning the entire system.
Okay, so may not use marijuana at any time and may not apply for a medical marijuana card without prior permission from this court. May not possess or purchase a firearm or other dangerous weapon. May not use any object as a weapon. May not engage in any harassing, violent, threatening, or stalking behavior toward anyone. May not have any contact with Kayla Bevere, Chris Shattuck, or Colin Lemire. Can't use have anyone else contact them. Can't use any social media to look them up or try to contact them. Okay?
I don't know social media.
All right, now, you must contact pretrial services by 4 p.m. on the day you're released from custody. All right, anything further, Attorney Vachon?
No, Your Honor.
Smith. Okay, anything further, Attorney Anid?
Yeah, so I must have misheard. Was there a dollar amount to the cash bond?
10,000.
10,000 cash charity?
Yes, sir.
Thank you. And then lastly, was the GPS ordered if he was released? If not,
That's not necessary.
No,
I have
okay.
children.
Just a minute. All right. I'm just going to answer his question. No, I'm looking at the circuit court bond, which, no, it was not. Okay.
Thank you.
Now, sir, what would you like to say?
First and foremost, how much you said that for each day that the bond isn't posted, there would be the credit amount. I'm not. I just want to throw this out there for Latavius Thornton. Once again, he accepts that offer for the credit amount to be $1,000 a day, and furthermore, he accepts other offers from the prosecuting attorney's office if they are willing to go day by day with Mr. Thornton, if he's incarcerated.
Well, that's good to know, but that's not on the table just yet, okay? And so what happens is you get credit for time, in this case, with that bond amount. Otherwise, if I were to give you what's called a PR bond, to say you can go, then you wouldn't get any credit for this time while you're waiting for that old case to be resolved. So, okay. So you're going to receive all of this in writing, and we will see you back 8:30 a.m., March 21st.
When you look at what's happening here, it's almost unbelievable. This defendant is standing in front of a judge insisting that he's not a person at all, he's an LLC. It's the kind of argument that sounds like it belongs in an internet chat room, not a courtroom. The idea that declaring yourself a business entity could somehow erase criminal responsibility simply doesn't hold up under any legal standard. The justice system runs on verifiable facts, not creative self-labels. A claim like that doesn't reveal cleverness. It highlights just how far removed from reality some of these sovereign citizen arguments have become. Watching it unfold, you can almost feel the confusion in the room as everyone tries to process what they are hearing. That it's strange to think that in a world filled with smart technology and futuristic inventions, we're still seeing people try to outwit the law with paperwork and wordplay. The contrast is almost comical. So when the judge set a $10,000 bond, it felt completely justified. The court had to send a message that these antics won't bypass accountability. If this man had walked out without consequences after making such claims, it would have raised serious questions about how far courtroom patience can really stretch.